What's up, fellow entrepreneurs? Today I want to talk about the Federal C.R.O.W.N. Act. But first, as always, I'm an attorney, but I'm not your attorney. So please find a competent attorney for your specific question or concerns. All right, so let's get into it. In March, the U.S. House of Representatives passed Bill H.R. 2116. This bill is known as the C.R.O.W.N. Act of 2021. C.R.O.W.N. is an acronym for Creating a Respectful and Open World for Natural Hair. If enacted into law, the C.R.O.W.N. Act would ban race-based hair discrimination. The bill specifically prohibits failing or refusing to hire, terminating, or discriminating against an individual based on hair textures or hairstyles commonly associated with a particular race or national origin. The bill lists the following as hairstyles that would be protected: hairstyles in which hair is tightly coiled or tightly curled, locks, cornrows, twists, braids, bantu knots, and afros. This legislation comes nearly 10 years after an Alabama employee unsuccessfully sued her employer for requiring her to cut her dreadlocks to allegedly fit the employer's grooming standards. The company in that case was accused of revoking its job offer to the plaintiff to work as a customer service representative after she refused a request from Human Resources to change her natural hairstyle. In 2013, the Equal Employment Opportunity Commission filed a lawsuit on behalf of the plaintiff against the company. However, an Alabama district court ruled the company's refusal to hire plaintiff because she wore dreadlocks did not violate federal civil rights laws. In 2016, the 11th Circuit Court of Appeals upheld the district court's ruling. The drafter of the C.R.O.W.N. Act of 2021 says that hair texture and hairstyle have been used throughout U.S. history in conjunction with skin color to classify people on the basis of race. They further said that racial and national origin discrimination occurs as a result of biases and stereotypes associated with hair texture and styles. The bill is headed to the U.S. Senate for a vote. The bill has received support from the White House, but the narrow Democratic majority in the state Senate may result in the C.R.O.W.N. Act falling short of approval. For us California business owners, we are already familiar with California's C.R.O.W.N. Act. I spoke about this in 2019. In fact, California was the first state to adopt the law in July 2019. The federal bill and the California's C.R.O.W.N. Act are nearly identical regarding workplace discrimination. California's laws started a wave of similar laws being passed in other states like Colorado, Connecticut, Delaware, Maryland, Nebraska, New Jersey, New Mexico, New York, Oregon, Washington, and Virginia. California employers are subject to the California's version of the C.R.O.W.N. Act, whether or not the U.S. Senate approves the federal bill. Employers should revisit their EEO anti-discrimination policy, hiring policies, and dress code and grooming policies to ensure that they are neutral and inclusive. Any policy regarding race should be amended to include hair texture or protective hairstyles such as braids, locks, twists, or bantu knots. All right, so that is the news on the federal C.R.O.W.N. Act. Whether it passes or not, California still has its version, so it likely does not make much of a difference for us California employers. But I found this news interesting because I like to keep track of how many California laws are being adopted at the federal level and with other states, because it just seems like whatever California does, other states or the federal government and other states start to follow. All right, so let's be aware of all these new laws coming up at the federal level, even though most of them are not as strict as California law anyway. All right, so until next time, be productive.